Morning, everyone. I'm Judge Jackie Powell. This is First Appearance Court. Today, I'll let you know if I've determined probable cause from the police reports I read this morning, and then we will also talk about release conditions. Today is not your trial date, and so, nor is it an adversarial hearing, and so I encourage you to speak with your attorney before speaking on the record, because everything in this courtroom is being recorded and can be used against you at a later time. For those of you who are represented by the attorneys from the Public Defender's Office, in the courtroom this morning, I have with me Mr. Fabric, and over at the main jail, Mr. Romero, and these attorneys are available to you, those of you who are at the other facilities by phone. For those of you who are represented by private counsel, your attorney will come to the courtroom and address your case from here. If your attorney is not here, you can let me know, and if you know the attorney's name and/or have the phone number, I will be happy to make a phone call. But please don't tell me that you are represented by private counsel if in fact you or your family did not retain this attorney for this arrest. Because an attorney has represented you in the past or may be representing you on a pending matter does not automatically mean that they're representing you on this new arrest. And I get this quite often, and then I make the phone calls, and I'm told that they're not representing you here, so I just want to make that clear. For those of you who, you also need to know that in the courtroom with me, I have the attorney from the State Attorney's Office, Mr. Eric Linder, as well as I have representatives from confinement status, pretrial supervision, and the clerk of courts, and these persons are here to help with the morning's hearing. They can provide additional information if needed. Some of you today may be able to resolve your case if it's a misdemeanor or a municipal ordinance matter, but that's going to be dependent on what's going on with you personally and what's going on with the case. For others of you who are charged with felony matters, violation of probation matters where the judge has already signed a warrant with a no bond hold, those cannot be changed or addressed here at first appearance. You will have to go before your division judge for that. All right? After today, your case will be assigned to a specific division judge, and then moving forward, any pretrial motions, or if you end up going to trial, those matters will be heard by that judge. All right, we have a few cases this morning that the jail has asked us to call out of turn. And I didn't write down the phone number, so Mr. Fabric, if it's needed. Well, Mr. Hernandez needs a Spanish interpreter, so we're waiting on that, right? Robert Shea,
Mr. Shea is approaching, Judge. You see her at Maine. Mr.
Okay.
Shea, come on up, please.
Page 16.
all right, so Mr. Shea's on page 16. Mr. Shea, you're before the court this morning. Charge 1 is burglary with assault or battery. Number 2 is possession of drug paraphernalia, and I find probable cause. Does Mr. Shea have any priors?
Your Honor, this state is going to be seeking a no bond hold upon a finding of proof evident or presumption great. I do believe the allegations satisfy the elements of the offense, and I would note the alleged victim in this case was an off-duty police officer working a detail that had no connection whatsoever to Mr. Shea. My concern is, frankly, I believe, and especially after speaking with the alleged victim, that there are mental health issues in this matter combined with substance abuse issues, and I just don't know the level of those issues and the details of those issues to what other special conditions could be in place to properly address them. Additionally, I believe Mr. Shea is transient. As you can see, he has a illicit address in Sebastian. He was arrested this year for domestic violence battery. It wasn't domestic, a battery in Sebastian in Indian River, that was dropped. Additionally, he has an non-expiring injunction against a different individual, a woman, and it appears this was out of New Jersey. And that was non-expiring issued June of this year. It does appear that Mr. Shea is from the Northeast. I see that he was born in New York. So I suspect he does not have strong ties to the community also. When I spoke with the alleged victim this morning, while he stated he doesn't necessarily have he doesn't have safety concerns for himself. He does, based on his interaction with Mr. Shea, have concerns for the safety of the community at large, considering this was a completely unprovoked attack, and he's concerned that it could happen again to another person just randomly.
Okay. All right. All right, does the defense wish to be heard?
Judge, we would be asking that, I don't know, did the court, and I apologize, did the court find proof evident presumption great?
Oh, well, that's where we are.
Oh, okay.
They just asked,
We would ask the court not to find proof evident presumption great. That's the highest burden in the criminal justice system. We feel that in this case, and again, there may be other issues, as the state pointed out, but we would ask the court not to find proof evident presumption great with regards to this. If the court does find proof evident presumption great, I'm asking the court to use its discretion to set a bond in this case. And I know Mr. Romero has, I believe, spoken to him and can maybe, if the court would consider that, would be able to enlighten the court with regards to any additional information or a potential bond that could be set.
all right, the allegations, of course, are concerning. It's reported that this officer was sitting in his vehicle, that Mr. Shea just ran up and started yelling at him, and then it punched him in the head through the driver door window. And then he attempted to keep the door shut to keep him in. There was a struggle, and Mr. Shea continued to punch the officer until backup was able to arrive. And so, based on these allegations, I understand that there may be other things going on here. I will be willing to sign an order for a psychosocial evaluation, but at this time, on charge 1, I am going to make a preliminary finding of proof evident presumption great. This is without prejudice for him to have a bond hearing before his division judge. Until such time, he'll be held no bond, okay?
Your Honor, the only,
Judge, we're gonna go ahead and order photo order as well.
Okay,
only other request I would make, Your Honor, if you could instruct the clerk, I noticed looking at and I'm sure they would do this anyways, I just, in an abundance of caution, for the alleged victim, a phone number is listed. If the court could instruct the clerk to make sure to redact that. I'm not concerned about the address, because that's actually the department's address.
so if you'll put a note, that the victim's phone number needs to be redacted from the clerk's file. All right? All right, Corey Bailey.
He's here present, Judge O'May.
All right, Mr. Bailey is before the court this morning. Charge 1 is possession of cocaine. Number 2 is possession of methamphetamine. Number 3, trespassing, occupied structure, or conveyance. And I find probable cause for these charges.
Judge, nothing's added this time.
All right. So, Mr. Bailey has standard bonds in place, which I will leave at this time.
That's where I'm looking.
All right, on our sign-ins, on page 7, Mark Walton.
Mr. Walton, come on up. Here's your private attorney, Mr. Bradley.
All right, good morning, Mr. Walton. You're before the court this morning on one charge of aggravated battery. Offender knew or should have known that the victim is pregnant. I find probable cause.
Morning, Your Honor. Mike Gottlieb and Clark Strandell on behalf of Mr. Walton.
Good morning.
While we dispute the veracity of the charges, we'll agree that there is probable cause.
Okay?
Good morning, Your Honor. Stephanie Newman on behalf of the state. We are seeking a number of special conditions in this case, Your Honor. We're asking that there be no contact with the victim. We're also asking, according to his NCIC, he still has a concealed weapons permit. We are asking that that be surrendered immediately, that if he is in the possession of any firearms, that those be surrendered immediately prior to his release. We are also asking, based on his criminal history, that the court include a substance abuse evaluation and any follow-up treatment recommended as a condition of his release.
What priors require that?
Judge, he showed, I show an arrest for a DUI with a .08 blood alcohol level or above in April of 2016, possession of cannabis, February of 2019, a battery arrest, February of 2019. Both of those were null prost in Miami-Dade County in August of this year. He also had, in April of this year, a carrying a concealed firearm arrest that was pled to a lesser included offense of open carrying of a weapon in September of this year, resisting without violence, possession of cannabis, and reckless driving. Those 4 counts were one charge. The arrest was in April. The possession of cannabis was null pros, but the other 3 charges were a plea in August. It was vacated and then resentenced, it looks like, or the probation was vacated in September of this year. But in light of the prior DUI and possessions of cannabis, several arrests, we would be asking for substance abuse as a condition of bond.
As the state said, Judge, all marijuana charges were dismissed. I did represent Mr. Walton in Miami with Mr. Strandell, and the DUI was also dismissed. So while there's a history of arrests for those offenses, he's never been found guilty on any of the substance abuse charges. I did agree with the state to a $10,000 bond. So, I mean, I understand the condition. My client is an NFL player. He is being monitored for a drug problem through the NFL. So I don't really have a problem with it, but I don't think it's necessary either.
All right, so, and so you're saying that all the DUIs and all the cannabis charges, those charges were all dismissed?
Yes.
There's no disposition for the DUI on his NCIC or his driver's license record.
Okay,
I didn't represent him on that, Judge, but my recollection from reviewing was that charge was in fact dismissed. I did represent him on the 2 marijuana charges. They were both dismissed.
all right. So based on the finding of probable cause, and I am going to impose a $10,000 bond, no victim contact, and Mr. Walton, that means no phone calls, no text messages, no social media, no third-party contact, and that no victim contact is in place until that order is lifted by a judge. Do you understand that, sir? All right.
Judge, for the record, that victim is Jasmine Thompson.
Okay. All right, I'm also going to order that he surrenders any weapons if he has any.
Yes, ma'am.
As well as his concealed weapons permit.
Sealed weapons permit. All right, Mr. Gottlieb, are you representing that Mr. Walton is currently subjected to other drug testing?
I believe he is, Judge. Candidly, it's probably a little dicey. He was released from the Miami Dolphins, but prior to that, while he was signed, he was being monitored and participating in a drug program. So at this point in time, I don't, without him having employment in the NFL, I can't say that he actually is. But again, I'll advise him to go and do it and get drug or alcohol therapy on his own. I don't think we need the court's intervention for that.
And regardless of what's going on in the NFL, I'm asking for a court order that he
Right,
have an
right.
evaluation and any follow-up treatment recommended.
Which is why I'm asking if he is currently under something. If he's not, then I am going to order the substance abuse evaluation and any follow-up that's required. Okay? All right. All right, thanks.
Thank you.
All right, Judge, thank you so much. Have a nice day.
You too. All right. On page 1, Lanette McKizzy.
Maine.
Olivia McKenzie?
No,
That's
Lanette,
probably,
Lanette McKizzy at Maine. She's at Maine.
She's here, Judge, in this morning.
All right, Ms. McKizzy, you're before the court this morning on 3 misdemeanor cases. You failed to appear in court a few times. and the charges are all the same, it's prostitution. So I find probable cause, and what does Ms. McKizzy want to do today? Ma'am, what do you want to do today? You have the option, you have $50 bonds on each of these charges at this time, that the judge who issued the warrant issued a $50 bond, so you have a total of $150 in bond. You can post those bond and go to court before your division judge. Or you can resolve these cases today, and I'll hear what the offer is from the city of Hollywood if you wish to resolve the case today. So what do you want to do?
Resolve it today.
All right.
It's time served, Your Honor.
All right, so City of Hollywood, to resolve all three cases, is offering adjudication and time served. Do you wish to accept that?
I accept.
All right, please raise your right hand. Do you swear or affirm to tell the truth?
I do.
Okay, you can put your hand down. And Ms. McKizzy, do you understand everything we've discussed here this morning?
Yes.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No, ma'am.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No.
And do you understand, ma'am, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter at this time? Guilty?
No content.
Okay, I accept your no contest plea. Find that it's freely and voluntarily given. Your sentence, ma'am, is adjudication, time served. Good luck.
Look, ma'am.
Thank you.
On page 9, Stephen Thomas.
Stephen Thomas. At Maine. Is he in the room?
He's North Broward, Your Honor.
North Broward?
Oh, it's Devontae Thomas.
No, Stephen. You have Stephen?
Yes, Stephen.
Okay.
How you doing today, Judge?
I'm well, Mr. Thomas. Mr. Plant, is it Stephen Thomas that you wanted, or is it?
It was Devontae Thomas.
All right, well, Mr. Stephen is here,
Yeah,
so, so Stephen Thomas,
Stephen.
you're before the court on a possession of drug paraphernalia charge. It's a first-degree misdemeanor, sir. I find probable cause. You have $100 bond.
Paraphernalia.
Judge, I did have an opportunity to speak to him, and he indicated that if the court's willing, he'd like to try to resolve the case today.
All right, State, you have an offer for Mr. Stephen Thomas?
So, the offer. Is he registered? Your Honor, due to a conviction back in the mid-eighties, I'm not he's not in my system and I'm not sure, I don't know if pretrial is information. He may be registered, so there would be potential consequences to
Oh.
cleaning this out.
Oh, okay.
It was, I just want to show, without putting it on the record, I just want to show Mr. Farbarek what I'm referring to.
Okay, sure.
Find the page, is that all right?
Sir, would you be able to, if I had the judge set the bond at $1, would you be able to bond out? Could you have somebody,
$1. If I had $1.
would you have somebody, would they be able to post that for you?
$1?
Yeah.
Sir, I ain't got nothing.
All right, I'll ROR Mr. Thomas. Mr. Thomas, you need to stay in touch with your attorney so that you'll know when you have to come back to court. You also have the responsibility of making sure that the clerk's office have your correct address. I'll let you know that currently it's showing that your address is 2307 Northwest 8th Street. Maybe that's apartment number 3, I don't know, Fort Lauderdale. Is that correct?
Yes, sir.
All right, so that's where they're going to send the notices, and so you need to know if you don't show up, We've put it on the record that that's your address and that you've acknowledged that that's where you get your mail.
Yes, ma'am.
All right, sir. All right, so Devontae Thomas.
At Maine, Your Honor.
Good, all right, man. That's it.
Devontae Thomas,
All right, Mr. Devontae Thomas, you're before the court on a misdemeanor, KPS on a municipal ordinance violation. You did not show up for a hearing on September 9th. The charge there is possession of controlled substance. I find probable cause.
judge's office, adjudication withheld, so he keeps his
Withhold
license.
adjudication.
They keep
All
his
right,
license.
Mr. Thomas, if you wish to resolve your case today, the city is offering withhold adjudication and court costs to resolve your case. Do you wish to accept that, sir?
I don't understand.
If you want to resolve your case today, that means if you want to take a plea today, the city, because it's a city ordinance violation, is offering withhold adjudication, which means it'll be on your record as no conviction, and then you will have to pay the court costs. How much is the court cost on this position? Well, it's
over
it's
200.
city, so
$200 or he, I
On
think,
the-
does this qualify for a
even on the
community
city, I think it's 200, it's
It's
in the
90?
$78 on the city ordinance.
Okay.
So those are your options. Also, there is a third option. This is a City of Fort Lauderdale case, and the City of Fort Lauderdale has a community court that is held every Wednesday with Judge Florence Barner over at the City Hall. If you opt to go to community court, you would have to participate in the community court program. They provide services for whatever it is that you need. And if you're able to complete the program, then at the end of that, they'll drop the charge. So you have three options. You can post your bond, you can resolve the case today, or you can go to community court to deal with that.
You'd be RR and just go to community court next Wednesday.
Okay, I can do that.
You can do community court. Here's the thing, if you don't show up for community court, I'm gonna sign an order and say that I've transferred your case to community court. Next Wednesday, you have to be there. If you don't show up, then they're gonna send it back here and they're gonna issue a warrant for your arrest. So do you understand that? Okay.
I do.
All right, so at this time, Mr. Thomas, do you know where Fort Lauderdale City Hall is?
No, I do not.
All right, I'm going to ask someone if they'll write it down. It's 100 North Andrews Avenue.
Okay.
All right, it's right on the corner there of Andrews and, what is that? Broward? No,
It's a block north of
it's a
Broward.
block north of Broward Boulevard. So 100 North Andrews Avenue, you show up there by 9 o'clock. I tell people to get there by 9 o'clock. I think they start a little bit later, but if you get there at 9 o'clock, you know that you will be on time.
Okay.
All right.
Next
So,
Wednesday.
so I'm gonna ask Judge Barner next Wednesday if you showed up, so I'm gonna be checking. All right, so ROR, and then I'll transfer your case to community court, okay?
See you there, sir.
All right, sir, good luck.
Thank you, Judge.
See the documents, okay, please.
Mr. Patron, I don't see the case that you signed in for.
See the document, please.
Okay, thank you. I'll start from the top again, I don't see it.
I don't think Mr. Forbear
It's
sees
no
it either.
paperwork.
There's no
See,
paperwork.
that's why I don't see it.
It'll probably be on the PM document.
Yeah, it didn't make the morning docket is what that means.
Even though it's on the docket.
But it's on the docket, but it says no paperwork. So if it says no paperwork there, it's not here.
All right, so I'll come back, I guess, this afternoon.
Okay, see you later.
All right, Your Honor.
All right. All right, the Spanish interpreter is here. Who needed the Spanish interpreter?
Judge, there are, I believe, 3 gentlemen at Maine that require Spanish interpreter. It'd be Mr. Hernandez on page 13, Mr. Diaz on page 8, and Mr. Morales on page 22.
We have Mr. Hernandez. And who was the other person on page 22?
Mr. Morales? Sergio Morales.
Morales. All right, so Luis Diaz.
Senor
El
Diaz,
señor Luis Díaz Díaz.
please approaching, Judge. Men, por favor.
Ah,
Madam Interpreter, if you'll raise your right hand. Do you swear or affirm to interpret from Spanish to English and English to Spanish?
I do.
All
Maria
right.
Salazar, certified court interpreter.
Thank you, Ms. Salazar. Mr. Luis Diaz,
Señor Luis Díaz,
you are before the court today, sir.
señor, usted está acá enfrente de la corte el día de hoy.
Charge 1 is operating without a valid driver's license.
El primer cargo es manejar sin una licencia válida.
Number 2 is a traffic KPS.
El segundo cargo es una orden de arresto por un asunto de tránsito.
This KPS was issued on November 5.
Presentaron esta orden de arresto noviembre 5
And with a bond of $100.
y eso lleva una fianza de $100.
I find probable cause.
Encuentro causa probable para el delito.
And, yes, Mr.
Judge,
Romero.
nothing to add. Nothing to add from Mr. Diaz.
All right, so he has standard bond of $125.
Le van a poner la fianza estándar de $125.
All right, Yoscar Hernandez Ramos.
Senor Hernandez? He's approaching, Judge.
All right, Mr. Hernandez Ramos is before the court.
Señor Hernández Ramos, usted está acá enfrente a la corte hoy.
Charge 1 is failure to obey police or fire department.
El primer cargo es que usted no obedeció a la policía o una persona del departamento de bomberos.
Number 2, aggravated assault on a law enforcement officer.
El segundo cargo es agresión con agravantes contra un oficial de la ley.
Number 3 is resisting officer without violence.
El tercer cargo es resistir al oficial sin violencia. Resistir y obstruir sin violencia al oficial.
All right, I don't find probable cause for number 2.
Para el segundo cargo, la jueza no encuentra causa probable.
It says that he brandished a knife
Dice que usted sacó una cuchilla
and he began to blade his body in a threatening and aggressive manner and began taking deep breaths.
y que usted empezó a moverse en una forma agresiva.
But when you read further on, it seems like they were more afraid that he was going to harm himself than harm others.
Pero pensaron los oficiales de que usted podía hacerse daño a usted mismo, no contra otros.
It looks like he brandished a knife when his wife was giving him the trespassing warning.
Usted empezó a blandir esa cuchilla cuando su esposa le estaba advirtiendo de la entrada prohibida.
Your Honor, it does mention, that there was fear for the other officers on scene.
Que sí se menciona en la acusación de que tenían temor por los otros oficiales que estaban en la escena del delito.
As well as concern that he may harm himself.
Asimismo, temor de que usted se hiciera daño a sí mismo.
Based on the allegation that he was blading his body, is described blading his body in a threatening and aggressive manner.
Y también hay en la descripción de que usted estaba moviéndose en una forma agresiva.
I think there is reason to have concern that he could pose a threat to others in addition to himself.
Estoy viendo de que es posible de que ellos pensaran de que usted se podía hacer daño a sí mismo y a las otras personas que estaban en la escena.
All right, I'm not gonna find probable cause for number 2.
La señora jueza no va a encontrar causa probable para el segundo delito, la segunda acusación.
It's the 24 hours.
Okay,
I'm sorry, the interpreter.
Less than 24 hours.
24 hours of.
to perfect the probable cause.
Están solicitando otras 24 horas para revisar el affidavit de causa probable.
All right, I'll give the state 24 hours to perfect the
Le
number
están
2.
dando a la fiscalía las 24 horas para que revise más el affidavit de causa probable.
And at this time, finding probable cause for 1 and 3.
Encuentra la jueza causa probable para el primer delito y para el tercero.
I'll impose a $500 bond on 1.
En el primer cargo le va a poner $500 de fianza.
Judge, with regards to count 2, would the court consider setting some bond because otherwise there's no way for him to bond out at this point?
The state
Tienen
asking
que-
for 24 hours to perfect, I've granted that, so.
Tienen que, para el segundo cargo, tienen que dar 24 horas para que la fiscalía revise la acusación del segundo cargo.
And just for record purposes, since pursuant to administrative order, it's hold for magistrate.
Con respecto a las guías o lineamientos para el magistrado,
I don't know that the court is able to set a bond until there is a finding of probable cause.
no opino de que sea posible que la jueza le fije una fianza hasta que no se encuentre causa probable para esa acusación.
All right, thank you.
Thank you, Judge.
All right, Sergio Mireles.
He's here, main judge.
All right, Mr. Mireles is before the court. Charge 1 is trafficking in cocaine.
El señor Sergio Mireles está acá enfrente de la corte por tráfico de cocaína,
More than 28 grams, but less than 200 grams.
más de 28 gramos pero menos de 200 gramos.
Possession with intent to sell, manufacture, or deliver cocaine.
El segundo cargo es posesión con intención de entrega de cocaína
Within 1,000 feet of a place of worship or business.
en un perímetro de 1000 pies cerca de un lugar de culto o negocio.
Number 3 is possession of cocaine,
El tercer cargo es posesión de cocaína
and I find probable cause for these charges.
y encuentro causa probable para estos cargos.
Judge, Mr. Morales advised me he's no way going to be able to afford the post bond how it's currently set.
Su abogado está diciéndole a la jueza que usted no le va a ser posible presentar poner esa fianza tal cual como se ha dado ahora.
My understanding, and speaking to Mr. Morales, this is the first time he's been arrested in his life.
Entiendo que esta es la primera vez que el señor Mireles ha sido arrestado.
He's been living in our community for almost 2 years now.
Ha estado viviendo acá en esta comunidad por más de 2 años.
He's 22 years old.
Tiene 22 años.
He's working. He works for a company called Star Welding.
Usted está trabaja para una compañía que se llama Star Welding.
He's been employed there for about a year and a half.
Ha estado empleado en esa compañía por 1 año y medio.
He lives in Fort Lauderdale with his girlfriend.
Usted vive en Fort Lauderdale con su novia.
They rent a trailer, and their monthly rent is approximately $800 per month.
Rentan un trailer y la renta es aproximadamente $800 al mes.
And they've been living there for a year and a half.
Y han estado ustedes viviendo ahí por aproximadamente 1 año y medio.
He's solely going to be relying on his girlfriend to help post his monetary bond.
Está esperando que solamente puede pedirle a su novia que ponga la fianza.
She works at a dental office as a dental assistant.
Ella trabaja con un dentista como asistente de dentista.
Judge, I'm going to be asking the court to consider a $7,500 bond on count 1 and a $5,000 bond on count 2.
Está pidiendo su abogado que le ponga la fianza de $7,500 en el primero y $5,000 en el segundo.
So that the court keep the bonds in place.
El fiscal quiere que dejen la fianza que le han impuesto desde el principio, que la dejen puesta.
I believe they are reasonable considering, even with no history, from what I can tell,
Por lo que yo puedo ver, y aún si no tiene usted antecedentes,
Mr. Morales faces a 3-year minimum mandatory prison sentence on count 1 if convicted.
si a usted lo condenan, usted se enfrenta a un mínimo de 3 años en prisión, aunque sea la primera vez.
And count 2 is a first-degree felony.
Y el segundo cargo es una felonía del primer grado.
I would just note, as far as his financial resources,
Estoy viendo recién de que con respecto a sus recursos financieros,
that law enforcement found almost twice the minimum level of for trafficking in cocaine in the home.
los oficiales de la ley encontraron que usted tenía 2 veces el mínimo de cocaína en su posesión.
And the packaging is described as not for personal use and for sales.
La forma en cómo estaba empaquetada la droga no se considera que es para uso personal or sale, I'm sorry.
For sale.
Sino para venta.
And Mr. Morales even confessed that he does sell drugs for extra income.
Y que usted les confesó de que usted vendía drogas para obtener un ingreso extra.
Well, it appears that there was some investigation going on because
Aparentemente había una investigación que se estaba llevando a cabo
the search was as a result of a search warrant.
porque la forma que rebuscaron era debido a que había una orden de cateo que se había puesto anticipadamente.
And that search yielded 48 package bags of cocaine.
Y en esa búsqueda encontraron 48 paquetes de cocaína.
All right, at this time, I am going to leave the bonds in place.
En este momento voy a dejar las fianzas tal cual como se dieron al principio.
Is there anyone else who needs a Spanish interpreter?
¿Alguien más que necesite la intérprete?
All right, thank you.
You're welcome, Your Honor.
All right. So let's go back to the top. Odalis Fernandez Gomez.
She's the present judge here, ma'am. Come on up, ma'am.
All right, Ms. Gomez, you're before the court on a KPS that was issued October 7th. You did not show up for a hearing. And at that time, the judge issued a KPS with a $250 bond. You'll either see your judge, you'll go to a division judge tomorrow, or post your bond. I don't know what other options you wish to pursue.
Judge, I'm going to be asking the court to consider releasing Ms. Fernandez Gomez, ROR, or in the alternative on pretrial. Now, my understanding is, in speaking to her, she self-surrendered at the, I guess, Pembroke Pines Police Station. The reason why she advised me she missed court, unfortunately, she's been diagnosed with cancer. She's doing chemotherapy at Holy Cross. She's been here her whole entire life. Right now, Judge, she's undergoing treatment. She will be coming back to court, Judge, but it was just, unfortunately, with the news of her health, she advised me she made a mistake, but she will come back to court. And she's asking to be released, ROR on the alternative on pretrial.
You take medication? Any mental problems? Thinking about it right now?
Your Honor, I can tell you, and I certainly sympathize with Ms. Fernandez Gomez's situation. She actually sent a request to specifically have a status conference that was set before Judge Levy in September reset. That was granted by Judge Levy and set for October 7th. Then she did not appear. And then she finally didn't send a request, I guess, to have the KPS vacated till November 19th.
That was
sir.
going to be my question. If there's that situation going on, it would be a reasonable reason to ask any judge to reset your hearing. So that was going to be my question. Ms. Fernandez Gomez, I am going to put you on pretrial supervision because that is the only way I think that we can guarantee that if there is some legitimate excuse that you have, that somebody will know that it's correct. So at this time, I am going to ROR you to pretrial supervision. Ma'am, if you don't show up for pretrial supervision tomorrow, warrant will be issued for your arrest and you'll be back in this place. Do you understand that?
Yes, Your
So
Honor.
please, you report to pretrial tomorrow and then you'll be able to keep in touch with them and/or your attorney now that you have one. So if there's an issue, if there's some medical proof that you can provide for your attorney to present to the judge, all of that needs to be done. Do you understand that?
Yes, Your Honor.
All right, so pretrial supervision, and you must sign up by tomorrow morning.
Yes,
If you get out early, if you go today, okay?
I'm going today.
Okay, okay, so just follow the map. Good luck.
Thank you.
All right, Destiny Demps,
Judge, she refused court.
Ms. Demps refused.
She did, Judge, per North Broward.
Yeah, I got a lot of those up here today, Judge.
What are you doing up there, Deputy?
Today's my first day back in 5 weeks, don't blame me.
That's a good reason to blame you. All
They
right,
must not wanna come see me.
so Miss Demps refused. We will reset her for tomorrow and then we'll see what happens, okay? Christine Chavez,
Inappropriate?
inappropriate. I think she was from yesterday as well. All right, so we'll reset Mr. Chavez for tomorrow. Sheila Rupert,
Med reset?
Your Honor, she's been referred to Judge Lerner Wren.
Miss Rupert.
Yes.
All right, so Miss Rupert has a KPS and she has a $500 bond. If she's been referred to, we'll sign an order to transfer it to Judge Lerner Wren, please. And then she does not have to be reset. All right, Mel Quincy Macklin,
Is it Paul Ryan?
Paul
Should
Ryan,
be, Murray, Stewart, and then Crowley.
Mel Quince Macklin. All right,
Yes, Your Honor.
Miss Macklin, you're before the court this morning on one charge of these are add charges. Number 4 now is robbery with a firearm, and number 5, aggravated battery with a deadly weapon. And I find probable cause for these charges.
Your Honor, I'm going to be seeking a no bond hold on count 4 upon the finding of proof evident or presumption great. This is based on the probable cause affidavit and the alleged confession made by her co-arrestee and Ms. Macklin herself. On count 5, I'm going to be requesting a $15,000 bond, noting that, and this is referenced in the probable cause affidavit, that Ms. Macklin, before being add charged to this, is already being held no bond on another robbery firearm with the same MO as this matter.
Okay. All right, so,
Judge, I would just, in light of the fact that she's being held no bond on another case, at this time, we just reserve argument for the Arthur hearing if
all
necessary.
right, so based on these allegations, it appears that the victim was lured to an hotel and then attacked and robbed. So I find probable cause as to charge number 4. I am making a preliminary finding of proof evident presumption great. This is without prejudice, and you'll be held no bond until a further order of the court. And as to charge number 5, I'll impose a $10,000 bond, no victim contact. All right? All right, Lauren Tardif.
Main Joe.
So funny.
He's approaching, Judge.
All right, Ms. Tardif is before the court, 2 charges of burglary, unoccupied conveyance, unarmed. And I find probable cause. Does Ms. Tardif have any priors?
She has a pending matter. She's out on $3,600 worth of bond from late July of this year for aggravated assault, battery, and criminal mischief. She had an old resisting without violence, but based on the fact that she's out on a pending felony violent offense and these new allegations, state would be requesting a $3,500 bond on each count. No contact, no return.
Judge, normally on a 3rd-degree felony, I'd be asking for 1,000 each, but considering what Mr. Lunder is saying, I'm asking for the court to consider imposing a $2,000 bond on count 1 and on count 2, total $4,000. Right now, Ms. Tardif advised me she lost her job. She was working at a medical center as an assistant, making about $14 an hour. Now she's currently looking for work. She's been unemployed since about Halloween. Now she lives in Fort Lauderdale by herself. Her monthly rent is $875, and right now she's in doubt how she's going to come up with the rent for next month. The only person that's going to be able to help assist her in posting a bond is her mother, and she's retired on Social Security. That is why we're asking for the court to consider a $4,000 bond on Ms. Tarter's behalf.
All right, I'm going to do 2,500 on each count. Okay. Which is a total of $5,000 bonds. Just so I can understand this sign-in, is this person not on the docket? Is that what's going on?
Yes, Your Honor.
The person is not on the docket?
Yes, correct, Your Honor. I was just gonna wait.
Okay,
Court has a break.
okay. All right, Susan Murray?
North Broward, Your Honor.
Ms. Murray is before the court on one charge of robbery, no firearm or weapon, and I find probable cause.
Can I speak to her?
Hold on just a moment, someone else is speaking.
A revocation was
Yes.
taken to Judge Kohler and he signed it and she's being held no bond. She will receive an ad charge.
All right, so, Ms. Murray, just also to let you know that I've just been advised that your division Judge Kohler has signed a no bond hold on a violation of a pretrial.
Yes, Your Honor, this was a copy.
Okay.
Okay, so you have a no bond hold as well. Is that
Okay.
something that you used to come back for? No, because there's an order that's signed.
Yes, Your Honor, it's just gonna go to the. Right.
All right,
If I could just ask Patrice, do you know what the case number is?
14319 CF10A.
Thank you.
Your Honor, in light of that, the state would be requesting a $7,500 bond on the strong arm robbery. She also has a prior strong arm robbery from 2016. As far as theft-related matters, grand theft, uttering a forged instrument, theft, another theft, those are from the 90s.
okay. All right, there was something you wanted to say or no more? Ma'am?
Me,
Yes,
ma'am?
yes, you were asking if you could say something.
Yes, I was asking, well, it's a matter now because Judge Cole revoked it because my mom is 80 and nobody is to take care of her but me. So that was the first reason that I was on pretrial. But I didn't rob
No,
the
ma'am,
lady.
please don't talk
All
about
right,
that, please.
you have a $7,500 bond, ma'am, on this new arrest, okay?
Yes, ma'am.
All right. All right, Kristen Stewart?
It's North Broward again, Your Honor.
Judge, I do have a probable cause argument on this.
All right, go ahead, Mr. Faber.
Judge, it appears that on counts 2 and 3, none of the drugs were, it doesn't indicate that they were either tested nor was poison control called.
Yeah, that's fine, Judge. I'm not asking for any time on those.
All right, so Ms. Stewart, you're before the court on one charge of uttering a false instrument. The other two charges, the possession of heroin and possession of controlled substance, I find no probable cause. And, do the parties wish to be heard further as to bond?
No, Your Honor, I just ask that you leave count 1 as is.
All right, so you have a $1,000 bond, ma'am.
Yes, ma'am. Do you mind if I say something?
I don't know if your attorney does.
Don't talk about the facts of the case. Okay, your bond's $1,000, and if you contact a bondsman, usually they take 10%, which would be $100 to bond out.
Of course. Yeah, no, I was just gonna, that's fine then.
All right,
Or-
Khadijah Hill? All right, Ms. Hill is before the court on one charge of grand theft, and I find probable cause.
Judge, and I think that this time I'm going to be contacting Ms. Hill's family, puts her bond.
All right, Ms. Hill has a $1,000 bond.
Come on, Ms. Crowley.
All right, Shavera Crowley,
North Broward, I believe. And on the X?
all right, Ms. Crowley is before the court. Charges 1 and 2 are petty theft, Number 3 is a felony capias, which has a no bond hold, and that is not for magistrate. 4 and 5 are traffic capiases, and those both have $1,000 bonds attached to them. I find probable cause, and I'll leave the standard bonds in place. You will see your division judge tomorrow on the felony capias, okay?
Yes, ma'am.
Do we have Joan Marie Marsaro today?
Med reset,
Still medical. And how about Ebony McLemore?
also a med reset.
All right. Tario Lionel.
Please approach and Judge Herman.
All right, Mr. Lionel, you're before the court on charge 1 is aggravated battery on a person 65 years or older, and number 2 is a domestic battery by strangulation, and I find probable cause. Does Mr. Lionel have any priors?
Does pretrial have any priors? Thank you. Your Honor, I'm going to be requesting a $7,500 bond on each count based on the level of violence, the condition of the alleged victim in count 1, and obviously would be seeking an order of no victim contact.
All right, Mr. Romero. Judge, as you heard, Mr. Lionel has a clean record. He's 21 years old. He's currently working. He works for an auto detail company. He's been there about 2 months, and he gets paid about $90 a day. Now, he will be living separate and apart from the alleged victim. I did advise him due to the domestic situation, the court's going to order no contact. He will be adhering to that order. The person he's going to be reaching out to help post his monetary bond is his mother. His mother, my understanding, is a school teacher. So, in students for Lionel, I'm going to be requesting, based on the fact he has no priors, $2,500 bond on count 1, $2,500 bond on count 2, total $5,000.
Just to note that the allegations are against a 75-year-old aunt. They're arguing over a pizza box that was left in the front yard. Defendant became irate, approached the victim who was sitting in the living room. And there's another witness that advised the defendant pushed the victim in the upper chest. Once she got up, the defendant proceeded to get in the victim's personal space and was still yelling. Out of self-defense, she picked up a candle and hit the defendant in the head. He became more irate, grabbed the front of the victim's throat with his hands, and that he attempted to pull the defendant. The witness stated that he attempted to pull the defendant's arm back while standing behind him. All 3 parties proceeded to fall onto the ground, breaking a nearby vase. The defendant was still attempting to choke the victim while on the ground. His cousin then proceeded to help pull the defendant off of the victim. The victim was able to go outside. The witness stated that the defendant proceeded to run out of the residence towards the victim, and while outside, that's when police law enforcement arrived. $7,500 bond on each count, no victim contact. And that means no phone calls, no text messages, no social media, no third-party contact. Do you understand that, sir?
Yes, ma'am.
Okay. All right, Fadi Falota.
Mr. Falota, come on up, please. I'm sorry.
Mr. Filota is before the court. Charge 1 is domestic battery by strangulation. Number 2 is false imprisonment. Number 3, tampering in a third-degree felony proceeding. I find probable cause for these charges. I'll hear from the state.
Okay. Your Honor, I see no history. But based on the allegations, and I do think they are aggravating in nature, I'm gonna be requesting the following amounts. 10,000 on count 1, 10,000 on count 2, 5,000 on count 3, no victim contact, pretrial release of the GPS monitor. I'm also going to be requesting a passport surrender to the clerk of the court prior to his release from custody.
All right, Mr. Romero?
Judges, you heard Mr. Filota has no prior contact with the criminal justice system. He's 32 years old, been here in South Florida now, residing for the past 3 years. He works at Walgreens. He's been there for 2 years, making about $16 an hour. He will find a separate place to live, separate and apart from the alleged victim. The only person that could help him with this post-monetary bond is his father. From what he informed me, he works at a tile company. Judge, I'm going to be asking for the court to consider setting a $2,500 bond on count 1, $2,500 bond on count 2, and $1,000 on count 3. So we're requesting a total of $6,000 on his behalf, Judge.
All right. These allegations in this probable cause affidavit are quite alarming. The allegations are that he started striking the victim. She was awoken by being stricken in the face multiple times. Then she was dragged to the living room, dragged out of the bed into the living room, and in the presence of the 2 children and the defendant's parents, the defendant began striking the victim in the face with both hands. The victim stated that she used her arms and hands to guard his strikes, but they were unsuccessful. Defendant grabbed the victim's cell phone and all of the phones in the house in order to keep the victim from calling 911. The victim stated that once the defendant calmed down, she attempted to run from the living room outside the front door to escape. She stated that the defendant and his mother ran outside giving chase and capturing her in the driveway area. The victim and the defendant and the mother grabbed her by her hair and forced her back into the house. Once inside the house, the defendant began striking the victim with a closed fist, causing the victim to sustain bruising on her right upper arm and scratch mark on her left upper arm. The defendant began choking the victim with both hands, cutting off her airway and circulation for approximately a minute. She stated that she was not able to breathe, feeling like she was going to pass out. And while the defendant was choking her, he stated multiple times that he was going to kill her and that in Egypt, she would be dead in 5 minutes. The victim stated that the mother-in-law stepped in while being choked and pled with the defendant to stop and not to kill the victim. She was finally able to get outside and to get a neighbor to call 911. And it's alleged that this defendant took all of the victim's documents, such as her passport, ID cards, immigration paperwork, in an attempt to keep her confined to the residence and not to allow her to leave on her own free will. Law enforcement attempted to locate the documents for the alleged victim, but has been unable to do so. All right, I am going to impose a $20,000 bond on charge one, $10,000 bond on two, and a $10,000 bond on three. No victim contact. And sir, that means no phone calls, no text messages, no social media, no third-party contact. Do you understand that, Mr. Filota?
Yes, ma'am.
All right. And if Mr. Filota is to surrender his passport to the clerk's office prior to being released, and to not apply for a new one during the pendency of this case. All right. All right, Talib Capers. All right, Mr. Capers is before the court. 2 charges of battery on a person 65 years of age or older. Number 3 is criminal mischief. And I find probable cause.
Mr. Keepers is currently being supervised by services in case number 19-10746 SM10 for battery. The subject was found.
He was arrested October 24th. I believe it was at that time.
And does he have any other priors other than the pending battery?
Your Honor, one moment. Honor, I will advise the court of the priors, but I just want to, if it's okay with the court, if I could make some recommendations. I'm going to be requesting, one moment, $20,000 bond on counts 1 and 2. Should he post bond, pretrial release of the GPS monitor? First, I can advise the court our office had contact with Madge Capers. She has safety concerns. She's concerned he will return to the home if out of custody. She did mention the incident from a few weeks ago involving his brother. And I believe that happened at this same residence as well. Additionally, he has priors. In 2006 in Broward, he was convicted of battery on a victim over the age of 65. 03, leaving the scene of an accident with an injury, and he received a withhold on the battery in 2000. Out of Dade County, in 2011, he was convicted of attempted armed carjacking, trespass in 2010, trespass 09, an arrest for aggravated, for battery on a victim over the age of 65, that was dropped. Criminal mischief in 2010, that was dismissed. Convicted of battery 2010, trespass 2010. Another trespass in 2010, and another one in 2011.
Right, Mr. Romero.
Judge, Mr. Kate, not working, he gets disability, informs me approximately $500 a month. For all practical purposes, Mr. Capers is financially indigent.
All right, pretrial has asked that I revoke his pretrial. And so at this time, I am going to grant that revocation on case number 19-010-746 MM10A, and I'm going to impose a $2,500 bond on that charge. Okay? And the charge there is battery. And now he's before the court. He has two other battery charges. Looks like defendant is mother, the victim is his mother. And there are references that there are cause for concern. He threw a brick through the, smashing out the driver's side window of her vehicle. He punched her in her face. I think that more needs to be done here. At this time, I am going to impose a $10,000 bond on each, on 1 and 2, and leave that $100 bond in place, okay? All right, Joshua Barbosa.
Your Honor,
Yes.
just as
No.
far as,
I know Mr. Capers, if we can bring Mr. Capers back. Did I put it down there? All right. I need Mr. Capers back, please.
He's coming back, Judge. Yes.
All right, Mr. Capers, a no victim contact. A no victim contact means no phone calls, no text messages, no social media, no third-party contact. I'm actually ordering a 500 feet stay away order. Do you understand that, Mr. Capers?
As far as what?
What, you cannot go back to the residence, and you cannot,
I'm gonna find somewhere to stay. I just gotta go and get my state ID.
no, you're not going back there for anything. No victim contact and no return.
Your Honor,
Yes.
I just want to see something here. And I think that's,
Judge, can he go one time with law enforcement?
No.
To get his property state issued ID?
No.
and Your Honor, and I know the court didn't order, but I just, for record purposes, that is part of the concern that the victims have and why the state is requesting a GPS monitor, because I'm not certain that he was allowed to be at that home to begin with, considering.
Is there already a no contact order in place?
And his brother lives at that residence. I was reviewing the probable cause affidavit from that incident. His brother resides at that location. The incident involving his brother took place at that home.
But is it on record that there's a no contact order with the brother?
Yeah,
Because it
yeah,
looks
sure.
like there was a fight with the brother, that's how this all started, or there was something with the brother.
Oh, yeah, no, the case that, he was on pretrial involves the battery arrest against his brother.
Was it level 2 pretrial?
No, there was just standard pretrial, but no contact.
Okay. All
And
right,
that's why I checked the PC to see, was
it
it the
doesn't
same
live anywhere.
residence as in this matter, and it is.
all right. So, Mr. Capers, I'm adding a level 2 pretrial supervision as well. All right. All right, let's see. I have someone signed in on Isaac Saravia on page 17. Oh, good morning, sir. Just one moment. All right, so Mr. Saravia is before the court. Charge 1 is aggravated assault with a deadly weapon without intent to kill. Number 2 is resisting officer without violence. And number 3 is a misdemeanor capias that Capias is on a municipal ordinance charge for possessing alcohol on the beach or in public area. That Capias was issued last year, November 30th of 2018, and that judge had assigned a $100 bond to that charge. Okay, so I find probable cause for these charges this morning. And on the Capias matter, it looks like he'll have court tomorrow before his division judge at 9 a.m. On the other matters, we need to address bond. All right, sir, do you wish to speak?
Yeah, what happened, what took place with,
Don't tell me about the case.
I won't.
Today is not the day for
I get it,
the
I
trial, right? How are you related to Mr.
I'm
Saravia?
his father.
Okay, and, all right, so you can talk to me about setting bond, if you're gonna post this bond, how much bond you can afford, anything like that. Because when I read this, you were not at the location of this incident, correct?
No, I
Okay.
ended up getting there afterwards.
Okay, all right, so let's talk about, how much bond you can afford, or maybe if you wanna wait until you hear what the state is recommending, so you can respond to that, all right? All right, Mr. Linder?
Your Honor, I'm not showing any history. It's based on the level of violence, I'd be requesting a $2,500 bond. No victim contact, no return, no possession of any weapons.
Whereas if you use a bondsman, that you pay 10% and use a bondsman.
I really can't afford that much right now at this point. My wife is not working, and it's pretty much only me supporting everything, including my son is not working at this time as well. Is there anything possible that could be done?
All right, so it looks like there are two persons that are involved in this incident. Mr. Saravia looks like is the one who pulled out a knife and pointed it towards the victim. He's not working, so is he in school?
Yes, he is in school.
Where
George
does
T.
he go to
Baker.
school?
George T. Baker Aviation.
How long has he been enrolled there?
He's been enrolled for about a year.
Is that a specialized school?
It's a specialized school,
For
yes.
what?
For aviation mechanic, aviation technician.
Okay, and how is he doing in school?
He had some issues before. He had to stay off. He had to get out and work another full-time job, two part-time jobs in order to pay for his car. And then he got that back together, and now he's enrolled in school again. But he's a very bright student. He's very intelligent, not violent at all.
It's not gonna take you that long to explain the situation to her, is it?
No, right?
I understand.
Okay, all right, good.
I will release Mr. Saravia to level 2 pretrial supervision. That means he'll be on an ankle monitor, does not have to post a monetary bond, but he'll be under supervision, all right? He lives with you, correct?
He lives with my mother.
All right, so they will
grandmother.
have to verify his address. Pretrial will have to do a verification of his address, that it's okay for him to be there. They'll go to the jail and fit him with an ankle monitor, and then he'll be released. Okay?
And does that mean,
No victim contact, and no return to that location. Cannot go back there, and no contact with his, I don't know if the other person, with his co-arrestee, whose
friend.
name is Mr. Vento.
Yeah.
All right, so,
Judge, just so the court's aware, there's also a capias for a municipal ordinance. The bond's $100 on that.
it's ROR and
Okay.
everything, okay?
So, Your Honor.
Yes,
so
sir.
He would be at the residence of my mother's house.
The level
and
2
actually-
allows him to go to work, school, church, anything that is, necessary.
Okay.
He can do that, he'll just have to let the pretrial office know what he's doing. If he has a job interview, he can let them know, and he has to report it so that they know that he's going, where he's going and when.
Okay, so he has to stay in contact with the people
Yes.
that are watching him.
Yes, and they will give him further instructions when they go to meet with him.
Okay.
All right?
Okay. Very good.
All right, sir, thank you. Mr. Saravia, the only thing I can say at this time is that you've got to make better choices. Right? All right. Joshua Barbosa,
Conti?
Mr. Barbosa, you're before the court on one charge of felony battery with a prior, well, it's a change of charge, felony battery with a prior conviction.
What, Your Honor, if I could have the case number, please? I wasn't given paperwork on this.
I don't have it on the docket.
19012 882 CF10A.
Notice they said
Is
there's an
that-
attachment, but there was no attachment.
There is no attachment?
There was an email sent out about this noting an attachment, but there was no attachment. I never got that.
Yeah, it's a KPS, it says change of charge from touch or strike battery to felony battery with prior conviction.
And Your Honor, I can tell you, the bond was originally set at $2,000.
Okay?
I'd ask that that bond be kept in place.
All right,
There was
so-
also a-
Go ahead.
Does the GPS monitor need to get reordered, Madam Pretrial? Okay.
So it's a bond plus GPS? All right, so Mr. Barbosa, here's what's happening. They've just changed the nature of the charge that you originally came before the court on. But I'm leaving the bonds and all the other conditions in place. So even though they've changed the charge, it'd still be a $2,000 bond with a level 2 pretrial supervision. Okay?
But I'm already sentenced here till the 17th of December.
What does that mean? You're not sentenced on this case,
Oh, okay.
right?
I think I am. Because
has
I
he-
feel there was a violation of probation and that's
Has he-
why I'm here.
This wasn't a violation.
This is not a violation of probation, though.
Okay.
All right? This is a case that's in front of,
Leaving.
no, this is a case that's in front of Judge Allspector.
He's been county sentenced on a VOP on a misdemeanor battery that he had.
All right, so you resolved the misdemeanor battery, but this case is a felony matter that's before Judge Allspector. Okay?
Okay.
All right, Carlos Jarigi, Conti. All right, Mr. Jarigi, you're before the court. This is an ad charge for petty theft. So this is now charge number 5. This is an incident that occurred on October 8, 2019 in Pembroke Pines. So I find probable cause, and you have a $100 bond at this time. All right, Alex Eve Jenkins.
Who's approaching Judge here at Maine? Mr. Jenkins, come on up, please.
Mr. Jenkins is before the court on a touch or strike battery. I find probable cause.
Judge, I'm gonna be asking the court to consider releasing Mr. Jenkins on pre-trial release. He's works in landscaping, he only gets $50 a day. Right now, he's living with his sister, but unfortunately, she just lost her job, so no one can afford to post a bond, so that's why I'm asking for pre-trial release on this misdemeanor offense.
Does Mr. Jenkins have any priors?
Yeah, yes, Your Honor. I believe he got out of prison somewhat recently. There was a 2015 possession of PVP. He violated probation August 15th of last year and was sentenced to 18 months state prison. He had a 2011 burglary of a conveyance with battery and aggravated battery. He violated probation on that case on August 15th of last year and sentenced to 18 months state prison on that case as well. Another battery in '07, disorderly conduct '09.
I don't know, the alleged victim was attacked in her sleep. All right, finding probable cause, I'm leaving the bond at $1,000. Paul Rivera,
He's here, main judge. Good morning, Your Honor.
good morning, Mr. Rivera. You're charged with petty theft. I find probable cause.
Judge, it's being Mr. Rivera, he wishes to resolve this matter today.
One moment, Judge.
The question is, did they get the money back?
Yeah, I don't know, and
Because it says that he took the money and fled. And it doesn't, he was identified, but it doesn't say that the money was retrieved.
not sure, and I can also advise the court, looks like Mr. Rivera is out right now in a possession of cocaine and trespass.
All right, so Mr. Rivera, I'm leaving your bond at $100. There may be restitution that we don't know about. Ian Burns, all right, Mr. Burns is charged with trespassing, and I find probable cause.
Judge, and it's being Mr. Bones, he wishes to resolve this matter today.
Mr. Burns is currently being supervised by pretrial services in case number 19-6760 CF10A. One count of battery on a law enforcement officer, one count of assault on a law enforcement officer. Based on this court finding of probable cause, we're gonna ask him to report back. That case was filed in June of this year. Initially, he was on a GPS and then went down to standard.
Do you know, is he still supposed to be at Pompano Beginners? Just asking, because I believe when he was initially released, that was the condition. Yeah, no,
Judge, and it's being Mr. Burns, from what I've heard, I guess he's out on pretrial. He's trying to talk to him as far as how this could potentially affect him. However, he still wants me to ask the court, he still is interested in resolving this trespass offense.
And I still stay at Pompano Beginners, I just wasn't court ordered there. I went to the other property, I was on second court, now I'm on the Fort Lauderdale property. So I was gonna see if I could resolve this case and then return back to the pretrial thing, or the other case, please.
he's being supervised by a pretrial, is the basis for, is the new arrest the basis for the revocation of pretrial? Did he sign up? Did he,
Initially, he was on a GPS.
has he been reporting?
He was initially on GPS, and then I saw where
Mm-hmm.
Coleman issued a no bond capias. It should be attached, it should be placed on him.
It's from Judge Coleman.
Yeah, it was issued Monday.
All right, Mr. Burns, you've got lots of other things going on here at this time, so I'm gonna leave the $25 bond in place. It looks like you have a no bond, hold from Judge Coleman. You have to go to Judge Coleman.
When is that hearing?
I don't know. All right, Ronkevis Williams,
Your Honor, that's North Broward. He refused. Come on, Mr. Rizzo, you're next.
well, that'd probably be because he's been here several times this week. Or if not this week, in the
Recently,
past,
yeah.
in the recent times. How much bond was it? I think probably yesterday he was here. How much bond does,
Well, I don't think he was here. It was a change of charge.
okay?
He might have been in court. I can tell you he's got several no bond holds, one for a robbery firearm, some VOP holds, including burglary and robbery, a no bond hold on an armed burglary of a dwelling. The case yesterday was a change of charge. It was a technicality from an attempted robbery. Bond was set at $2,500. I was planning on asking the court to set these bonds at $5,000 each.
All right, Mr. Williams refused, and like I said, he's been before the court more than once already, so at this time, I am going to find probable cause in absentia, and I will, impose a $5,000 bond on charge number 9 and charge number 10. Okay? All right, all right. All right, Justin Rizzo?
North Broward.
All right, Mr. Rizzo, this is also an ad charge, sir. I know Mr. Rizzo has also been before the court, so this is this says number 19. It's a KPS for delivering methamphetamine, and you have a $2,500 bond. I'll leave that in place, okay?
Let him have his booklet. I put it on the desk. $2,500 on 19.
All right, Archie McNair.
One moment, Judge. Page 10. When I call him, he didn't answer. Judge, he's in court 4870.
And this is on a KPS, so for Judge Coleman, does he,
If I could have one moment, Your Honor, I just want to check to see if he's in court on this case.
okay?
Yes, Your Honor, he's being arraigned on this case. I don't know, Mr. Farber has.
Division Judge?
I'm
Or
sorry?
is who's,
Judge,
he's
he's-
represented by the PDs?
Yes, and
Oh.
he's in front of Judge Coleman. I don't know if Mr. Farber has an objection, but considering he's being advised of the charges this morning, I'd ask that the bond be kept in place.
That's fine, Judge, and just subject to whatever Judge Coleman decides.
Of course.
Okay, that definitely. All right. Jason Murray?
Conti, Your Honor.
All right, Mr. Murray is before the court these are also add charges. Mr. Murray, charge number 2 is robbery with a firearm. Number 2 is aggravated battery with a deadly weapon. I find probable cause, I believe his co-defendant was handled earlier. All right, so,
Your Honor, I'd be making the same request for the same reasons stated earlier. Additionally, Mr. Murray is also being held no bond on another robbery firearm, like his co-arrestee. As mentioned in the PC affidavit, they were co-arrestees in that matter as well.
all right. All right, so it appears that, based on these allegations, the same MO that the co-arrestee is luring someone to this hotel, and then the person is attacked by Mr. Murray, and they're attacked and robbed at gunpoint. So I find probable cause as to charge number 2. I am going to make a preliminary finding of proof evident presumption great. This is without prejudice for you to have a bond hearing before your division judge based on State v. Arthur. And as to charge number 3, which is the aggravated battery with a deadly weapon, I am going to impose a $5,000 bond.
Your Honor?
Yes?
And just for uniformity, I just, because I couldn't remember, you said a $10,000 bond on his co-arrestee? I just asked that they have the same
On
bond.
charge number 3?
Yeah, on the aggravated battery.
Okay, so $10,000 bond. No victim contact, no return to that location. All right. All right, Javaris Fleming. All right, Mr. Fleming also was before the court this week, correct?
Yes, Your Honor, on an arrest warrant.
All right, so it looks like there's a number of bond surrenders on felony charges. So 4, 5, 6, and 7 are bond surrenders, and those are not for magistrate. Number 2 is a domestic battery by strangulation, dating relationship. Number 3 is a touch or strike battery, also from a dating relationship. There's this from a not in custody KPS, from an incident that occurred October 30th of this year. All right, so find probable cause.
Your Honor,
Mr. Fleming was here yesterday. Your Honor, I believe set a $10,000 bond on Mr. Fleming, a robbery, I believe by some snatching. My understanding as it currently stands, he can't afford that $10,000 bond, but he is working. He works at a place called Tire Hut. It's a warehouse, only getting paid $14 an hour. How it currently stands, I see that his bonds were surrendered on the other cases. So financially, no one's going to be able to post a monetary bond.
Your Honor, I'm requesting a $10,000 bond on 2, a $2,500 bond on 3. I would note the alleged victim in this case is actually his co-arrestee in the robbery case. This then occurred, going by the dates, 11 days after the robbery, Your Honor. Obviously, I'd be asking for no victim contact, and the court, I believe the court is aware it's listed on the docket or your paperwork, the charges.
Is she in custody?
I'd have to check to see if she is still in custody.
Oh, okay,
I know she came through on first appearance on the robbery.
okay.
I just remember the facts that they were both on a dirt bike or motorcycle.
Right.
She posted bond, Your Honor.
Mr. Fleming, $10,000 bond on charge number 2, $2,500 bond on number 3. You have all those, the bond surrenders, you're back to whatever those original bonds were. No victim contact, which means no phone calls, no text messages, no social media, no third-party contact. Do you understand that, sir? Do you understand the no contact order, sir?
Yes.
All right. Devon Perry,
Please approach the judge, ma'am.
Mr. Perry is before the court. Charge 1 is grand theft. Number 2 is driving while license suspended. Number 3, improper flashing lights. Number 4, driving without lights. 3 and 4 are traffic infractions, not for magistrate. I find probable cause.
Judge, at this time, nothing to add. I'm going to be contacting Mr. Perry's friends and family to request monetary bond.
All right, and so Mr. Perry has a $1,000 bond on 1. All right, just a moment. Mr. Linder,
ma'am.
that attorney that was there before said he was
He had to run to another hearing. He'll be coming back.
Did we-
It's, he's,
it's one of these complicated, it's not on your docket things?
Your Honor, if he was in my office, he's with statewide, so I prefer let him
Okay.
just.
All right, I am going to take a quick recess and then we'll be right back. All right, we are back on the record. Tavares Welsh.
Mr. Welch, come on up, please.
Mr. Welch is before the court. Charge 1 is grand theft of a firearm. And numbers 2 through 11 are possession of weapon or ammo by a convicted U.S. felon. And I find probable cause for these charges. Yes.
Just, I would advise the court of Mr. Welch's history. 2002, this is out of Broward, 2002 burglary of a structure, attempted burglary of a dwelling and theft, 10-year state prison as a habitual offender and PRR offender, 02 burglary of a dwelling and grand theft, 15 years and a day, state prison, HO, PRR, 02 possession of firearm by convicted felon, burglary of a dwelling and grand theft, 15 years and a day, HO, PRR, strong arm robbery, 98, 2-year state prison as a habitual offender, 94 aggravated battery, burglary of a structure, 42 months state prison. I'm going to be requesting a $10,000 bond on count 2, $5,000 bond on count 3. Considering that every count is for individual ammunition, I have no objection to an ROR in counts 4 through 11.
Okay.
Judge, as here, Mr. Welch does have priors, however, from what he informed me, got out of prison 2017, and I think he's only had a minor contact with criminal justice since then. Having said that, he's not going to be able to afford a $16,000 bond. What we were going to be asking the court to consider is a $3,000 bond on count 2 and a $1,000 bond on count 3, making it a total of, if my math is correct, $5,000 bond on Mr. Welch's behalf. Now, right now he's working. Since he got out of custody, he's been working with the same demolition company now for almost 2 years. He's making about $12.50. He lives locally here in Fort Lauderdale with his mother. His mother's a caretaker. That's the only person that's going to be able to help post his bond, and that is why we're requesting that monetary amount, Judge.
All right, on charge 2, I'm imposing a $5,000 bond. On charge 3, a $5,000 bond. He has a $1,000 bond on 1, and I'll ROR on the other charges. All right, Van Tilly Bean.
He bonded, Judge. Oh, okay. Kevin Scott.
All right, I find probable cause.
Kevin Scott.
Kevin Scott.
Oh, Judge, if we can put on Rico, I believe he just went to the nurse, so he should be back.
Okay. Christian Altador.
Mr. Altador, come on up, sir.
All right, Mr. Altador is before the court this morning. Charge 1 is abuse of child without great bodily harm. Number 2 is neglect child without great bodily harm. Number 3, failure to stop or remain at an accident involving injury. Number 4, operating without a valid driver's license. Number 5, disobeying a red light. That's not for magistrate. I find probable cause for these charges. Any priors on Mr. Altador?
Yes, Judge. 2018, possession of cannabis, no valid DL. 2017, unlawful use of false name ID. 2016, 2 counts of delivery of PVP, the violation of probation, based on the totality of the circumstances and the allegations. State would be requesting $3,500 bonds on counts 1 and 2, $2,000 bond on 3, no victim contact.
Judge, and speaking of Altador, he's not going to be able to afford to post that bond, unfortunately. He just lost his job, and now he's looking for work. He was working at a warehouse called Gillextics, where he was making about $370 per week. He's the main financial provider of his household. He's living with his child and the mother of his child in an apartment where they've been living at for 8 months, and they pay about $950 in rent each month. Now, the mother of child is working. She works at Chipotle, only making about $9 an hour at most. Judge, using the services of a bondsman, she's going to be able to come up with what I'm going to be asking for is the $1,000 bond on each count, Judge.
Is Tiffany Harris the mother of the child?
No, Judge.
So the allegations are that he crashed into an officer's vehicle, and then there's a small child in the car. He grabbed the child and ran. By the time they found him, he was in the apartment of Tiffany Harris, well, it says occupant. I made contact with the occupants of the apartment, Tiffany Harris and Benjamin Joseph, and during my protective sweep of the home, I discovered the defendant in bed and pretending to sleep. And then they, oh, now I see. Then they made contact with the mother, and the child said that she was just in an accident with her father, and then he grabbed her and ran away, and she advised that she hit her head during the accident. All right, so $3,500 on charges 1 and 2. And then, 3,500 also on charge number 3. And no victim contact until further order of the court. And there's a $25 bond on number 4 that also remains. Okay. All right, James Fonseca.
Judge, I was told that he refused.
No problem.
Mr. Fonseca refused.
Judge, whenever the court's ready, Mr. Scott.
All right, so we'll reset Mr. Fonseca until tomorrow. We'll see what happens. And then Joseph Schwietert. Who's that, Mr. Romero?
Mr. Scott, Kevin Scott on page 13.
Oh, all right, Kevin Scott. Mr. Scott is before the court. Charge 1 is operating a motor vehicle with license expired. Number 2 is disobeying a stop sign. That's not for magistrate. 3 and 4 are violation of felony probation. Looks like you have probation with Judge Duffy. And so you'll see Judge Duffy tomorrow at 8:30 a.m. because those VOPs are no bond holds. You have a standard bond on 1, which I will leave in place. All right, Joseph Schweitert.
Mr. Schweitzer, come on up, please.
All right, sir, you are before the court. Charge 1 is resisting officer without violence. Number 2 is battery on a person 65 years or older. And then 3 to 8 are warrants on violation of pretrial. Those all have no bond holds, are not for magistrate, so you'll have to see Judge Lynch, it appears, on that. And then on charge number 9, it's a civil writ with a purge amount of $377. That's also not for magistrate. I find probable cause. And you have a $100 bond on 1. We need to set a bond on 2.
Your Honor, in light of the allegations in the case and the pending felonies that he has, I'd be requesting a $7,500 bond and no victim contact.
And Judge, considering he has no bond holds, I'm going to be asking for a $1,000 bond on count 2.
All right, based on the allegations, $7,500 bond on two. No victim contact. All right, Steneths agree.
Come on out here and have a seat. Come on up, please.
Please approach the judge.
Mr. Segrees, before the court, charge one is petty theft. It's felony petty theft, so it's a third-degree felony. Number two is grand theft. Number two is a felony capias. The charge is grand theft, and that capias is issued for Judge Colra with a no bond hold and is not for magistrate. So I find probable cause, and as charge one, you have a standard $750 bond. I'll leave that in place, okay? Tremaine McKenzie,
Mr. McKenzie, come on up, please.
Mr. McKenzie is before the court. Charge one is carrying a concealed firearm. 2 and 3 are possession of weapon or ammo by a convicted Florida felon. Number 4, possession of cocaine. Number 5, possession of cannabis 20 grams or less. And number 6 is a traffic infraction, not for magistrate. All right, I find probable cause.
Your Honor, the state would be requesting a $10,000 bond on count 2, $5,000 bond on count 3, pretrial release of the GPS monitor. Mr. McKenzie, in 2016, had a possession of firearm, ammunition by convicted felon, and discharging a firearm from a vehicle. He was sentenced to just under 39 and a half months in state prison, July 20th of last year. He was released from state prison September 26th of this year. He has additional priors for possession of heroin with intent to sell or distribute at a nearest school or place of worship. 2016, same prison sentence. 2014, robbery by sudden snatching. 2013, grand theft auto. 2013, possession of cocaine.
Judge McKenzie got out of prison. He's found a job. He's working for a mechanic in Deerfield Beach. He's making about $60 a day. He's living with his parents. My understanding is his mother works at Publix. Doesn't have much money, so we were going to be asking him for a $2,000 bond on count 2 and a $1,000 bond on count 3.
All right, Mr. McKenzie, I am imposing a $5,000 bond on 2, $5,000 bond on 3, plus level 2 pretrial supervision. The other standard bonds will remain in place. All right, Eric Hare,
North Broward, Your Honor. Come on in.
all right, Mr. Hare is before the court. Charge 1 is aggravated battery on a public or private education employee. Number 2 is an out-of-county misdemeanor hold. That is for Highlands County. And that charge there in Highlands County is also is a failure to appear on a domestic battery charge. All right, so I find probable cause.
Am I allowed to say something?
Is he represented by the Public Defender's Office?
Judge, he probably hasn't filled out an affidavit. They'll send somebody tomorrow for
Okay.
him. I would just caution you, sir, to not talk about the facts of the case. Don't say anything about the facts, okay? If you want to tell the judge your ties to the community or what bond you can afford, you can do that, but don't talk about the facts.
Alright. Never mind.
Okay.
All right, State?
Yes, Judge.
No, we're not done.
Based on the nature of the offense that he's out on and wanted in Highlands County, and this actually is a battery on an elected official or education employee, not aggravated battery.
It's a battery on a who?
Yeah, you are
I
referring
thought it
to.
says was it the teacher?
Yeah, it says the difference. It says aggravated battery on the booking,
Okay,
but on the PC, sir, on the PC, it's a battery, not an aggravated battery.
all right, why does it say battery on an elected official? Is that the
It's
statute?
just it's under the statute. It covers both.
Okay,
In light of that, Your Honor, I'd be requesting a $2,000 bond on count one. No victim contact.
well, aside from this Highlands County warrant that he has, is there something else? Does he have any other priors, is what I mean?
He has juveniles. I don't see anything else as an adult.
Judge, I can tell you that he currently isn't working and he has really no money in the bank. I don't know that he'd be able to afford the $2,000 bond that's set from Highlands County. What we would ask is the court to consider a lower bond with regards to count one that would make it at least maybe a little bit more possible for him to afford bond.
Well, the things that's concerning is that the charge in Highlands County is a domestic battery charge.
And Your Honor, I can tell you this is, at a minimum, not the first time there's been an allegation of Mr. Hare having issues with teachers. There was a charge out of Titusville. It was dropped, but I've never seen this charge. It was, it's in the system, it's labeled as poisoning water, but it appears he was putting some type of chemical compound in his teacher's drink. And her
Lavender oil
you
in
know, when
coffee, in the teacher's coffee?
Yes.
She put my dad's murder on smart board.
Sir, don't, we can hear you, don't say anything.
So the charge that the that's actually in the booking report, is that a third-degree felony and not a first-degree felony as,
I believe it will be, when charged properly, it's a third-degree felony.
okay. All right, on charge one, I am going to impose a $7,500 bond and order no victim contact. And this, all right, so you have a $7,500 bond on one, and from Highlands County, you have a $2,000 bond, okay? Ryan Nicotra. Mr. Nicotra is before the court on the one charge of possession of heroin, and I find probable cause.
Judge, nothing to add by the defense.
All right, Mr. Nicotra has a $1,000 bond. Matthew Lovingsheimer.
I'll call him in about half hour. Come on up, sir.
All right, Mr. Lovingsheimer is before the court. Charge one is fleeing and eluding law enforcement. Number two is operating motorcycle without a license. Number three is failure to register motor vehicle. Number four, operating without a valid driver's license. Number five, failure to have a a required endorsement. And number 6, disobeying or avoiding a traffic device. Number 6 is a traffic infraction. That's not for magistrate. I find probable cause.
Judge, I'm gonna be asking for a photo order.
All right, I'll sign the photo order, and and he has a $2,500 bond. Timothy Mejias.
I'll call him. Mr. Mejias, come on up, please.
All right, Mr. Mejias, charge 1 is possession of MDMA. Number 2 is grand theft. Numbers 3 through 7, dealing in stolen property. Numbers 8, 9, 10, 11, and 12. Is that correct? This is, that,
9 to 12
yes,
are misdemeanors.
are misdemeanors?
Yes. Count 8 is the felony, and then the rest of them are
All right, so secondhand dealer is number 8, but it's.
one was over 300 and one was under 100. So
Oh,
we
I
did
see.
2 different sections.
I see.
And we put all the felonies. Each
Oh,
one
okay.
felony section, and then the 40.
Okay.
Judge, which are the misdemeanors?
All right. So number 9, 10, 11, 12 are first-degree misdemeanors. Right? And then 13, 14, 15, and 16 are a violation of felony probation, and those have no bond holds. Okay? So I find probable cause, but 9, 10, 11, okay. And then Mr. Mejias has court tomorrow before his division judge on the violation matters, and I will leave the standard bonds in place. Jeffrey Winchell.
Mr. Winchell, come on up, please. Please approach the judge.
Mr. Winchell is before the court on 1 charge of possession of cocaine. Number 2 is possession of drug paraphernalia. Number 3 is a municipal ordinance violation. I find probable cause.
Judge, we're gonna be asking for a phone order.
Okay? And Mr. Winchell has a $1,000 bond. Jason Williams.
Mr. Williams. Come on up, sir.
Mr. Williams, you have a grand theft charge. I find probable cause.
Judge, I was gonna ask the court to consider releasing Mr. Williams on pretrial release. From what he advised me, no one's gonna be able to afford to post his bond. Now, right now, he is looking for work. The good news is he just went to a job interview yesterday at a place called Key Staff.
I just got laid off from my other job. I was working at a warehouse called Office on 19th Street.
So from what he had told me, that his interview went well. He believes he's gonna be hired. He lives in Lauderhill with his uncle, so he has a place to stay. But right now, he can't afford to post bond, so that's why he's asking for pretrial release.
Our state would be opposing pretrial. He has additional history, but the main thing the court should be aware of, 1, he's registered. He's gone to prison for the underlying offense. He's also gone to prison for failure to register.
All right, I find probable cause, and I'm going to leave the bond at $1,000. Michael Zarcone.
Mr. Come on up, sir.
All right. All right,
Also Zarko.
Mr. Zarcona, you're before the court on charge one is a violation of misdemeanor probation. And that has a no bond hold. Judge McHugh signed that warrant. Number two is a traffic capias. You have a $500 bond. Number three is a violation of felony probation. And that also has a no bond hold. That warrant was signed by Judge Yuson. So I find probable cause and you have to appear before these division judges on these violation of probation matters. Okay? David Pierce.
Judge, did you have an
Mr.
objection?
Pierce, come on up, please.
I have a probable cause objection.
Please approach the judge.
All right, Mr. Faber, go ahead.
Judge, the PC didn't indicate that any of the drugs were either tested nor that they were called in for identification.
Yeah, I did see that. So, Mr. Pierce, the charges presented are possession of controlled substance without a prescription, that's 1 and 2. Number 3 is a possession of drug paraphernalia. Number 4, operating without a valid driver's license. 5, 6, and 7 are traffic infractions, not for magistrate. So, as to 1 and 2, I find no probable cause.
State would request 24 hours, Judge.
Okay, the state has requested 24 hours to perfect, no PC in 1 and 2. I will grant that. And then the other bonds will remain in place. All right, Willio Pitioma.
Please approach the judge.
All right, Mr. Pitioma is before the court. Charge 1 is possession of cocaine. Number 2 is resisting officer without violence. Number 3, tamper with or fabricate physical evidence. 4 is a traffic infraction not for magistrate. Number 5 is a felony capias. And that has a no bond hold, and you'll go before Judge Fine tomorrow at 8:30 for the capias. All right? I find probable cause. And it looks like that capias was issued because you didn't show up for arraignment, so we issued a no bond capias. I find probable cause and leave the standard bonds in place. Okay. Robert Johnson.
Mr. Johnson is approaching, Judge. Mr. Johnson, come on out. And Judge, he declined the services of public defender. He advised me that he's going to hire Mr. Jeffrey Grossman.
Okay.
It's Mr. Grossman representing me in another case.
All right. I understand that, Mr. Johnson, but I need to make sure that you understand that for this hearing this morning, you are entitled to an attorney. Do you understand that?
Yes, ma'am.
All right. And so for today's purposes, you do have the right to represent yourself if that's what you want to do.
Okay.
So are you declining the services of the public defender's office at this time?
Yes, ma'am.
All right. So you are before the court this morning. The charge 1 is possession of a weapon, short-barreled gun rifle or machine gun. Number 2 is a violation of felony probation, and you have a no bond hold on that charge. So, I'm sorry?
I'm not on probation for a felony. I'm on probation for.
That's a
for
misdemeanor.
DUI.
It's a misdemeanor. I'm sorry. And it does say misdemeanor, but that's for Indian River. So it is a no bond hold. So I find probable cause and we need to set a bond on 1 and then,
Your Honor, the state's going to be seeking a $10,000 bond on count 1. It is cause for concern that allegedly Mr. Johnson's found in possession of bump stock, which, just stating for record purposes, my understanding is a device you could be attached, used on a firearm to allow a semi-automatic firearm to mimic an automatic firearm.
That's correct. Okay.
all right? Mr. Johnson, is there anything you wish to say in regards to setting your bond?
No, ma'am.
All right. So, you have a $10,000 bond on number one, okay?
Alrighty.
And, if you post your bond, you've got to surrender any weapons or firearms, that you have.
I already surrendered all my firearms.
Okay. All right, sir, good luck. Jaquez Etienne,
Judge, I've been informed he's in courtroom number 7750.
all right, this is an ad charge for an immigration hold. So, I find probable cause. It is a no bond hold and he has to appear before the immigration judge. John U. Harriet?
He's out to court, courtroom 4715.
Mr. U. Harriet is in court. We'll have to reset. And then Joseph Laban,
North Broward, Your Honor.
North Broward.
Save me for last, thank you.
All right, Mr. Laban is before the court. Sir, this is a change of charge. When you were arrested, it was burglary, committing a felony wearing a mask. Now it's burglary, unoccupied structure, unarmed. How much bond did he have before?
One moment, Your Honor.
Judge, I think he indicated to me when I spoke to him that he has already been in front of Judge Shear for this.
Okay,
So I don't know if
She
she
set
handled
a
the change
bond?
of charge.
or change,
Yeah.
or handle the
Yeah,
change of
sir.
charge? Yes, sir.
Yeah, I may say something. My bond was, 10,000 on the, burglary with the mask, and I've already bonded out on that, actually. And, then they said I have a capias on that charge, so now
Because
I'm
they
here.
did a change of charge.
Just so the court's aware, and I would ask that the court reimpose the bond in all release conditions. It's, was set at 10,000, no return to the, incident location, 500 feet stay away order, and GPS level 2.
Your Honor, if I may say one more thing.
Okay,
I'm self-employed, so I do a lot of, my income comes from a lot of freelancing, like, Amazon delivery, Uber Eats, and, DoorDash, etc. And I would like to, be put on, if possible, level 3 GPS, so I may continue providing income for my family.
11-2 does not prevent you from
Level
working.
And Your Honor, just so the court's aware,
Yes.
Mr. Laban is, excuse me, he's represented by Bob Trackman. Mr. Trackman has filed a motion, I don't know if he filed it before Mr. Laban posted bond, but filed for a motion for a bond reduction. So it's another reason why really any modifications, whether it be on bond or other release conditions, should be heard by
All
Judge
right,
Shear.
so, Mr. Laban, you have a private counsel, so what I am going to do at this time, who has already filed motions with your division judge, I am just going to leave everything in place the way it is, so that you know it's still the 10,000, the level 2 pre-trial, the 500 feet stay away, and that's going to be subjected to whatever your attorney does in your division with the division judge, okay?
Yes, ma'am.
All
Yes,
right,
ma'am.
sir. All right,
Do you see my bond, as posted yet, or?
I don't, well, it wouldn't be there now because it's a change of
It
charge.
might have been returned if it was
It might have
posted
been
at around the same
returned if
time.
there was a change of charge. So again, you need to talk to your attorney and the bondsman so that that can be rectified. Okay?
Okay, thank you.
All right, sir. All right, everyone, thank you. I think that's the end of our docket. Yes, ma'am. There's Deputy, welcome back.
Oh, I like to say it's good to be back, but
Oh, you can say it. Just say it.
it's been a tough week.
All right, take care.
All right, I'll see you at 1. Bye-bye.
Okay. Mr. Who? Yes. So we need to, is it there? Oh, I didn't put it on the determination. Yes, so we can fix that. We'll change it to $100 on the misdemeanor charges. What was the name of the defendant? So on Mr. Timothy Mejias, the charges, as we indicated before, was it 9, 10, and 11? And 12? Those are all misdemeanor charges, and so we're adjusting the bond amounts to $100. Okay? Do you need everything back so that we can make the correction?